Hello everybody, welcome back to the English Law Channel. So I'm carrying on with tort, and now I'm going to look at emotional harm and injuries that are of a psychiatric kind. So the law will protect you against personal injury to the body. Courts are loath to permit claims to succeed if therefore other types of harm, such as harm to your feelings or indeed to your mental health. But they do sometimes allow it and say never. So emotional and psychological harm, if that results from physical harm, that is recoverable. And claimants here have to recover for the consequential psychological harm that arises from pain and suffering or indeed loss of amenity. Loss of amenity, not being able to use something. So the loss of amenity means you can't enjoy whatever it is. And that can be caused by having to have a limb amputated, for instance. If there's emotional or psychological harm that arises from a traumatic physical injury, then yes, that too is recoverable. But the tricky bit here is when you claim that the injury here is solely emotional or psychological. There's no physical aspect to it all. So unless the psychiatric harm arises from a sudden event, then it won't count under this category. This is there to limit things, the psychiatric harm. There's a difference between claims for a medically recognized psychiatric condition, which results from a particular event, or things that happen immediately in the wake of it, like nervous shock, for instance. But simply sadness, however maudlin, is different. So stress, dismay are regarded as normal emotions which are going to happen from time to time, and then no compensation is payable for those. But more and more psychiatric injury is recognized as being something which is just as harmful to a person as a physical injury. So compensation is increasingly recoverable, but there is a direction of travel here in jurisprudence. So their defects, damage, and imminent risk. Let me look at those in greater depth. So there are rules about recovery, and physical damage to property is a type of damage that the law of tort will compensate. You have to bear in mind the claim about property is one based on damage to property and not defect in that property. So no claim in tort is there about defective property unless the defect in property causes a damage to other property or to a person. Anyway, so let me explain the difference between damage and defect. D&F Estates Limited against Church Commissioners for England 1989. Here there was damage, and they used the ordinary sense of the word damage, making a thing worse, not creating a thing badly in the first place, because a defect is when you manufacture it wrong. This is ab initio, it's somehow flawed. Therefore, if the result of a negligent inspection of foundations and property is built, the property becomes weakened and is no longer structurally sound, well, the negligent inspection hasn't caused the damage to the property, because the negligent act resulted when someone actually building it wrongly in the first instance. A defect per se is recoverable, and Lord Bridge sat in this D&F case. He says you allow recovery for defect in property. The defect is irrecoverable. Allowing recovery for a defect in property in the law of tort would be a non-contractual remedy as to whether it's suitable for the purpose for which it's made. These guarantees are part of contract law, not tort. So this issue is highly complex, because defect then can cause damage to other property. So can you then claim in respect to the property which has been damaged by the defect? Well, no. The defect in property simply causes the damage to itself and doesn't provide a reason for recovery. But if the defect causes damage to other property, then there can be damages. But the defect causing damage to that property which is defective is not recoverable in tort. So in tort, you can't recover for pure economic loss. There has to be some other sort of loss which can also then lead to economic loss, and that is recoverable. Economic loss on its own is not recoverable. So tort grants damages or compensation for lots of different types of loss or harm. Physical injury, as I said, these can arise from a road traffic accident, things happening at work which injure a person, medical negligence likewise. So the claimant might suffer some physical harm for this, and that may well lead to financial loss. They have to take time off for work, be incapable of working in a certain profession. Damage to property, which means that you can't use that property for work purposes. You might lose profits through injuries or damage to your property. So financial loss here, where it arises from a physical injury or damage to property, this is called consequential economic loss, and that is recoverable under tort. But consequential economic loss has to be distinguished from pure economic loss, because the law is dissimilar in these two spheres. There is no recovery for pure economic loss in tort. A person who hasn't been injured or suffered any damage to property cannot claim because of financial loss arising from another's wrongful conduct or negligent conduct. So the loss is not connected to physical injury, including death, or to damage to property, is known as pure economic loss, and that's irrecoverable. So why is that so? Is because otherwise there would be just so many claims, and the courts would be inundated. So the litigation would be excessive, and the undesirability of this is the reason why the courts have said you can virtually never do that, and the defendants would have excessive liability. Or Chief Justice Cardozo said, in an indeterminate amount or for an indeterminate time to an indeterminate class, as in just unlimited people, so many claims forever. That was in a case called Ultramarez Corporation and Touche, 1931. So financial interests are protected outside the realm of tort. The law of contract is seen as the apposite place for compensating financial losses. Anyway, there are very rare exceptions. So the absence of a duty of care and negligence for pure economic loss has developed if the loss is caused by a negligent misstatement. But that's quite specific, like if a accountant or a solicitor or something tells you something wrong when it's his job to get it right, and that causes you economic loss. Thing is, then that seems to overlap with contract. Anyway, damage has been caused carelessly because of advice, reference, information, or even services. You can sometimes claim if you satisfy certain requirements. Then there's insurance. So modern tort here is about providing the injured claimant with pecuniary compensation. The way to compensate the torts through a system of compulsory insurance is also vital, and about 90% of tort compensation comes from insurance, particularly when the injury results from a traffic accident or something going wrong at work. So insurance really bolsters the tort system, and unless the defendant is very well insured or very affluent, it's sometimes not worth the trouble or expense of claiming in tort, because even if you win, you'll get a negligible amount. So the insurance industry is very prevalent, and that is a major factor in many tort cases. So some people say, well, that actually seems to detract from tort. So insurance, defendants may well have an awful lot of money. So you can insure against liability in tort, and the occupiers of a premises, such as schools or people who own factories, or people like doctors, barristers, solicitors with malpractice insurance, have to be insured in case of various situations arising. Then there's also loss insurance. First-party insurance allows an individual to insure policies that will compensate him for personal injury or damage to the property of others, regardless of the fault of others. Then there's liability insurance, which is a bit different. Third-party insurance provides protection when the insured person or entity is liable for injury which is wrought to another or the property of another. So liability insurance is mandatory for drivers under the Road Traffic Act 1988. There's also Employers' Liability Compulsory Insurance Act 1969, and it obliges employers to have insurance about their people working for them, accidents and diseases which arise at work. The reasons we have tort is we have to uphold good standards of conduct, and this will have a dissuasive effect on people being careless. So we must force them to be prudent and diligent. But there are many circumstances where the deterrent effect is rather slight. Motorists are likely to drive carefully because they don't want to get injured or killed themselves, and they don't want to wreck their car. They can get prosecution, they can face ruinous fines, or they can be sent to jail. The fear of civil action for damages is not a major factor here. So the damages were going to come out of the insurance claim, although there is an incentive not to claim, no claims bonus, pay for it out of your own pocket, and after a few years your premium goes down so much that that's worth it. So some drivers may find insurance more expensive, or they might not be able to get insurance at all in the future if they've had to make lots of claims. So then there's the notion of no fault. Except in cases of the no-fault liability torts, intention or recklessness on the part of a defendant in tort action must be demonstrated. So if the person is careless, then that is vital in tort. Someone might be at fault in tort for the claimant, must be at fault in tort for someone, the claimant, to get some compensation, and then the person can be demonstrated to be a tortfeasor if he or she was careless. And that's why law of tort in modern times is principally guided by one cause of action: negligence, and neglecting to do your duty, not doing things with due care and attention. So fault is central to tort liability, but it wasn't recognised so much in the 19th century. It is only in the late 20th century the legal system has begun to concern itself ever more with the notion of fault. So tort law became what it is really in the 19th century, and there had to be a direct link between the defendant's act and the claimant's injury or the loss, and that was enough to prove liability in law. But the overarching principle here is that there's losses should lie where they fall, unless there's a particularly convincing reason for moving the loss away from where it falls. The fault of the party causing harm is usually put forward as a justificatory argument for moving loss away from where the loss falls. Toodaloo.